The Honourable the President.
Senator Haynes.
Thank you, Madam President. Before we left for the tea break, I was making the point that what the population is really hoping for and urging everyone who is responsible and in a space of leadership to have a productive conversation on crime prevention and what we can do to alleviate the problem that is facing us. And the legislation that has been before us has been at the other end of the spectrum. And it is not intended to make any of us safer, but it is overly criminalizing our state and creating a conversation that is inherently destructive to the rule of law and the system of natural justice, as it were. Madam President, it is not my intention to delay the proceedings of the Senate, since we have already been told that this piece of legislation will go to a special select committee. But I would like to close by saying and by agreeing with Senator Vieira that when we are thinking about legislation that requires a delicate balance, that we do so with logic, we do so with thinking about the kind of Trinidad and Tobago that we hope to see, thinking about the kind of society that we want to create, and that we don't pass legislation from a space of fear, but understanding that the things that we do directly impacts our society and the kind of society we hope to create. And I thank you.
Honourable Senators, I will suspend for exactly 5 minutes, and I hope that when I return, the relevant speakers will be in place.
Here is a roundup of the last parliamentary sitting in The Ayes Have It. The 42nd sitting of the House of Representatives took place on Monday, 9th September 2019 at 1:30 p.m. Leave of absence was granted to the MP for Shoguanas East, Mr. Fazal Karim, from that day's sitting of the House. The Firearms Amendment Bill 2019 was brought from the Senate. The Attorney General moved that the next stage of the bill be taken later in the proceedings. This motion was carried. 68 papers were laid, while 3 reports were presented. 3 urgent questions were posed. 8 questions qualified for oral answer. 7 were answered. Question 254 was deferred for 2 weeks. The Minister of Finance, the Honourable Colm Imbert MP, announced the reading of the budget estimates for fiscal 2020 on October 7, 2019. The Attorney General, the Honourable Faris Al-Rawi, MP, moved the second reading of the Firearms Amendment Bill 2019. Debate began on the bill with the MP for Naparima, Mr. Rodney Charles. He was followed by the MP for Port of Spain North, St. Anne's West, the Honourable Stuart Young. The MP for Caroni Central, Dr. Bohindradat Tiwari. The MP for Laventil West, the Honorable Fitzgerald Hines. The MP for Tabakit, Dr. Suraj Ratan Rambachan. The MP for Dago Martin West, the Honorable Dr. Keith Rowley. The MP for St. Augustine, Mr. Prakash Ramadar, and the MP for Kamutu Manzanilla, Mrs. Christine Nualo Hossain. Following debate, the bill was referred to the Committee of the Whole for consideration clause by clause. No amendments were made. With 30 votes for, 0 votes against, and no abstentions, the Firearms Amendment Bill 2019 was read a third time and passed. The sitting concluded at 9:36 p.m. and the House adjourned to Friday, 13 September 2019 at 1:30 p.m. Stay tuned for more reports of The Ayes Have It. For more information, visit our website at www.ttparliament.org and follow us on Facebook, YouTube, Twitter, and Instagram. Be viewing the Parliament channel on the Parliament Radio 105.5 FM on Friday, 13th September 2019 at 1:30 p.m. as we bring you live coverage of the 43rd sitting of the House of Representatives. At this sitting, debate is expected to begin on the Sexual Offences Amendment Bill 2019. You can also view a live stream of this sitting on our YouTube channel, ParlView. For more information, visit our website at www.ttparliament.org and follow us on Facebook, YouTube, Twitter, and Instagram.
The Honorable, the President.
Senator Dialsing.
Thank you, Madam President, for allowing me to partake in this discussion on this important piece of legislation. And first of all, I must say that as I spoke to persons on the outside, they mentioned to me that, we have to be cautious with certain pieces of legislation, that we don't erode the rights of individuals. And I was actually told that, the trend that they are seeing is that, the bail amendment bill, other pieces of legislation, it seems to me that even the firearms bill we had recently, it seems that persons may be certain persons may be thinking that we are trying to, go into pieces of legislation where you may need 2/5, the 3/3 majority. You need certain aspects where, we may be stepping on the Constitution by eroding the rights. And, I had to explain to that person, sometimes we have to make decisions here in this Senate here that, you look at the rights of the individual, you look at the rights of the accused, and you have to look at society at large. And this same balance that, that the same sort of problems that I see, that I had to face, the sort of thing I saw Senator Vera actually spoke about, the fact that he had to grapple with certain pieces of this legislation. So then I have to ask myself, what is the price we have to pay for this piece of legislation? Will it really be taking away the rights of some individual? And, we looked at certain pieces of legislation that came, and those pieces of legislation came because we found that there was a tardiness in the judicial system, magistrate cases taking too long. We found that, even there were talks about if there are a lot of cases for marijuana possession, we may have to look at certain laws to see, the problem that exists. We are changing the laws to try and get to those problems, while more efficient system in running the affairs of the judiciary, the police service, would actually, if more resources were spent in those departments, DPP's office, etc., we may not have to be running to Parliament to try and change these pieces of legislation. So, I look at why not improve the system first, and then, then we can implement our laws. We could change the laws, I mean, the death penalty is still in our law books. Why it's not implemented? But as it may, I love my country, and I would try in my best. I'll try my best, actually, to see if I can do any piece of good here to support the government and to support the Attorney General if, he can pass legislation that will give some social ease in the communities, because the communities are suffering from the crime, and as Senator Perez says, it's like a crime storm that we are experiencing. So I would look at this legislation, and I look at our country here where both evidence and both witnesses disappear. And it shows a system where much improvement is needed. So therefore, we have missing evidence. We have, witnesses. I remember certain cases where witnesses were gunned down just before the trial, and it was mentioned recently a doubles vendor and other individuals, even from Clint Hoggins' days, we remember that scenario, where persons were in protective custody, left, and they were gunned down. So we have to have a system where we can protect our witnesses, and we can also make sure that the full arm of the law is able to take its, its effect in finishing certain cases. So, the rule is that you are innocent until proven guilty. That's the golden rule. We have, people in prisons staying in conditions there that are left much to be desired. So any legislation which helps speed the process, I will support this once it does not shortcut the rights of the accused. And this is where I have some difficulties with certain pieces in this legislation. Now, it is well aware that the European Convention on Human Rights in 1962 spoke about the rights of the individual. Then the 1976 Constitution looked at the protection and freedom of individuals, and in particular, Section 5F says that, it looked like, that persons are presumed innocent until proven guilty according to the law, but this shall not invalidate a law by reason only that the law imposes on any such persons the burden of proving particular facts. Also, within that whole, subsection, the right to a fair and public hearing by an independent and impartial tribunal is there, reasonable bail is there. So again, I look at the caution that I may have to have in looking at these pieces of legislation. And as I looked at this bill, I noticed it was divided into evidence, it was divided into identification of suspects. And the identification mechanism that was set out in Division 2 and set out in Clause 4 in Sections 12A to 12B, all those new sections, it actually looked, from 12A to 12B. We actually were formalizing the standing orders that the police have been using. So it's not to say it's anything new. So those parts are easy takes on it. It's giving the police service a structure, giving the police officers a structure to work in, giving the individuals who come before the system a level where, if the recordings are there, you can have a level of recordings that are set up there, the video recordings, that if an attorney wants to challenge it, the evidence will be there. So those aspects of it, the 12A to 12B, I have no problem really in supporting those changes. But I must say, when I looked at some of these, Madam President, I wanted to make a comment here that when I looked at 12A, identification procedures in Division 2, and it actually includes Part C, you're looking at the, before any identification procedure takes place, a record shall be taken by the investigating officer of the first description of the suspect given by the eyewitness. So it actually gives a description of how, you can write down the description. It actually gives an idea of the conditions that are necessary. Distance of the eyewitness, the weather condition, lighting conditions, time, and particulars of and particulars that investigating officers think fit So I'm wondering there, should part of that, would that include any sort of, what I may say, if someone has any defects in their visual problems or any sort of declaration of their visual problems, that it should be somehow included in this piece of legislation. So I'm just thinking of that aspect of it. So if someone has a visual problem, should it be declared to the police officer? So when he's making that determination, it will be factored in to this. I also would like to look at the fact that when I looked at 12B, Part 7, where a person has not been positively identified by an eyewitness as a suspect, the Commissioner of Police shall cause all photographs of that person to be destroyed. Madam President, this Part 7 I'm looking at, when we looked at the PACE guidelines from the UK, the United Kingdom have the PACE guideline, the Police and Criminal Evidence Act. And when I looked at it, they actually went a bit further with this piece of legislation, where they were saying that why, at the PACE legislation, it says that the persons whose photographs are there should actually be witnessing the destruction of the photos. And I think I would like to expand that Part 7 there to come in sync with the PACE legislation, because I would hate to imagine I have a mugshot of me existing and which could influence somebody. And we all know having photos of persons in the police, if there's a file folder and they actually put in those photos to the person's witnesses, there are a lot of mistakes that can occur. And I want to elaborate the point that mistakes can occur from eyewitness, and if they are seeing photos of any one of us, they may mistake us and mistakenly think that we are also part of the criminal evidence. So I'm thinking that part I'd like to see if we can somehow expand. When I'm looking at Part 12C, and I want to look at the Part 12C, Section 6, where an eyewitness had previously made an identification of photographs or a computerized or artist composite or similar likeness, he shall not be reminded of such photographs or composite likeness or any description of the suspect once the suspect is available for identification by any other means. And when I looked at it, I understand why, that you may not, you should not remind somebody. There's a logic, you may not remind that, at least you have that person there now. But I may want to add that, you remember the police commissioner recently spoke about cold cases. So the cold cases, you have old cases existing. And I think he had promised there will be a team to look into those investigations and those old cases. And in cases like that, after a period of time, the memory of that individual may need to be jogged. And so I'm thinking this may go against the whole train where we have photos of those persons and we may have to show them it. And there are now computerized apps where even if you see an individual 5-10 years ago, that individual can be aged according to computer to see what they look like now. So with cold cases, I'm thinking somehow we will have to put something there in terms that we may not have to, but we may be able to remind the individual to jog his memory that, this was a suspect you had years ago, this is the photo of him, and this is his age photo that exists now. Something has to come into play, because I think there will be a problem with the process if we find somebody years after and we are not able to utilize something in the law for this. Madam President, I would like to look at Section 12G. And in 12G, suspect may have a representative. And 12G1, and subject to sections 12J5 and 12N, where a suspect is involved in an identification procedure, he shall be given a reasonable opportunity to have his representative present during the identification procedure. And when I looked at section 12G3, for the purpose of subsection 1, a suspect shall be given at least 9 hours notice of the time to be placed at which the identification procedure is to be conducted. I think that 9 hours is too little, and I'm hoping that, the AG could consider 12 hours at least. The traffic jam alone sometimes to go from certain parts of the country would probably preclude someone into this. So this is an avenue I think we have to look at the longer hours. But again, somewhere along here, Madam President, should be the methods that were used to contact the representative. Because in a case like this, it is easy for the police officers to say, we give one call, nobody answered. So I'm saying somehow we may have to tie into this some sort of directive where they actually will call someone, they could actually go to the scene of someone, because it's really, to me, it's a vital part of the whole system to have a representative present there to look at the proceedings. So another concern I had, Madam President, is if a representative is present. Now, a representative could be an attorney, but a representative, if they are present there to look at, the witness that you're looking at the lineup, will the representative be present in the same room as the witness? And this is where I have a little problem, because you see, my representative could be my fellow gang leader. My representative could be someone there who in the society, the community, is known as a person with certain questionable characteristics. And I would fear if I'm coming in as a witness to look, you have the screen there and you're going to look at that lineup, but in the room present with me is a representative who can give me that element of fear, or somehow just his presence there may make me change my mind and say I'm not going to give evidence again. So that aspect I'm thinking we have to look at. Do we put the representative there at a different time? Do we put them there in a different room? And this is something I'm hoping that we can get some answers to when it goes to the select committee. Another concern I have, it's actually with the actual setup of the room. And this I see here, it's identification parade, and it's under 12K. 1, an identification parade shall be conducted in a police station or other building under the control of or regularly used by police service in the normal conduct of their duties, either in a normal room, and I have some concern with a normal room, because having, a witness in a normal room without that screen to be, it gives just that level of fear. It defeats the whole purpose where we say we want to put certain pieces of legislation in place to protect the witness. So that normal room, I think we may have to consider that aspect to see why it's there and it shouldn't be there. Or one equipped with a screen permitting the witness to view the suspect without himself being seen. Madam President, sometimes you may have a screen, and there were instances where I know a witness went to give, to choose somebody in a lineup. And as the witness stood there, the alleged individual, the criminal, simply stared at that screen, stared at that one mirror. And just staring at that caused that witness to have that fear, to change their mind, to say, I'm not going, because he just simply stared. He probably wouldn't know at which point they stood in front of that mirror. But just looking at that individual staring at you can cause some problems. So I'm looking, does it have to be, and I'm hoping the AG can answer this, does it have to be a screen? I mean, we are looking at these pieces of legislation to improve the whole evidence and system. We are looking at putting in, as I say, those recommendations that look at AV, audiovisual evidence. So if we are going above the line, can't we have a lineup where you may not even have that mirror, but you can have the AV system could actually look at that individual, the lineup, look at that individual, make a judgment from a remote place. not necessarily the police station, because coming into the police station and a representative of ill repute coming into that police station can cause a witness to change their mind. So I'm thinking another way to protect that is if we can get some EV, another building, and you could look at that lineup in the same way and say, look, that individual, in that lineup is the one who I'm thinking that may have caused that crime. So the witness intimidation is something I'm hoping that we could address by this. Madam President, most of the other pieces of legislation here, when I looked at, I had no major issues, no major problems. I looked at the fact that, I commend the AG for the fact that the National Security Minister for the fact that, there are 20 rooms equipped with audiovisual recording capabilities. And I'm thinking, this shows that we are heading in the field of best practice. We are moving in the right direction. And, we have to look at these improvements. And most of these improvements, I support. Section 12C deals with objection by interview to video or audio recordings. Again, all those are pieces of the legislation which I support, because if you object to the video or audio, you go back to the old diary system. I need to say, though, that police officers should be trained for this new techniques and handling and interviewing. And this is something I'm thinking has to be done and should be done. When I looked at the fact that, the anticipation of, launching the video remand yard facility, this is something I commend the government on. It's long overdue. It's a cost. It's a horrendous cost to the taxpayers. It's 80 million a year. I heard some figures. 80 million a year to transport prisoners back and forth. So I will support any measures to help this. I mean, sometimes when you are driving and you see the transport vehicles blowing and pushing people off the road, that is a fear that persons have. It causes a lot of distress to drivers. So I'm looking for the day that we will not see these transport vehicles being like road bullies and people just having to move off the way. So that is something that I commend and I will fully support. Now, the issue, I think, where most people would have had difficulties is with the, when you have the anonymous witness there, and you're looking at that aspect. And I think this is what, may, as Senator Ferrer said, goes against the grains of, and I'm thinking that we are looking at this. Now, I'm seeing the need, but I'm also a bit cautious, and I have to be cautious. And you see, when we are looking at a witness that, I cannot question, I cannot look at, we have to see Madam President, that, if we are looking at going with science, there's Dr. Paul Ekman. He actually said that if we are looking and you're having cross-examination of people, there's something called facial action coding system. You look at each muscles there are 43 facial muscles, and this technique has been there for 50 years, where we look at micro expressions. Train. So that training is something that, some attorneys are so good at it. Some judges could look at somebody and read if they are lying. So in a sense, you by having this anonymous witness, you may be now putting those individuals at a disadvantage for this. And why I mentioned this facial action coding system is the fact that, you look at eye movement, lip movements, the FBI, CIA, all these people use these to actually look at utilize the face, voice, body language of potential assassins, terrorists. So it's a well-established field in science. And I am saying that it's there. It is to be utilized. There are experts trained on it. And why I mention this, Madam President, you see, if we have experts trained on this, and if we are thinking about anonymous witness, an anonymous witness. I'm thinking, if somebody is going to give evidence against me, and it's within the power of the judge to say, yes, I will give you that, you will be anonymous, I am thinking we should somehow utilize safeguards within that. And one of the safeguards I'm thinking is the judiciary should have access to personnel trained, psychologists trained in this technique. That if I'm a judge and I'm going to take away someone's right, and it is taking away someone's rights, I will now be able to have the experts trained to look at this witness, examine that witness and say, listen, judge, we don't think that person is telling the truth. So at least that training I think we need. And I'm submitting that if we have to look at the anonymous witness, besides looking at those personnel training in the facial recognition, we may have to look at also a lie detector test. So you're using more modalities that, that will help the judge decide that, listen, I would listen to this witness and probably allow that. So I'm thinking, looking at these scientific measures, modalities, I'm thinking we have to probably put that and factor that in. And when I looked at the piece of legislation, it went into details about the lighting system, the distance, the measurement, the weather condition, and even there are personnel trained now in forensic science where they study the lighting. They call them the lighting experts, where they could look at the lighting, they could look and see, if somehow the obstruction of the view of that individual, if, he could have made a mistake. And again, we have to factor those personnel into the equation to assist the judiciary and to assist the judges. But, Madam President, I have a problem also. Even if we look at the individuals and we test them with facial recognition and we test them with a lie detector test, and the lighting expert comes on the scene and studies all the dynamics and said, well, they can probably at that distance and see. It will help us scientifically. But you see, there's a problem where you look at the whole eyewitness system, and really speaking, from cases that we had, globally, it looked like, the eyewitness system is not really a reliable system. So here you are, we are dependent on the eyewitness, and an eyewitness may see, or the eyewitness may think, or actually believe. Yeah.
Please, I'm not going to ask anyone to leave the chamber this time, but please try and silence your mobile phones, please.
Yeah. Thank you, Madam President. So what I'm saying is that there's what you call the Innocence Project, Madam President. And the Innocence Project, they looked at the DNA, what you call it is DNA exonerations. So they looked at DNA evidence and they looked at certain crimes that were committed. And up to date, it's 367 DNA-based exonerations were given. But you see why I mentioned that, Madam President, the startling thing is, out of those 367 DNA exonerations, 69%, the eyewitness claimed that those persons were the persons involved in the crime. So 69% you had eyewitness misidentification. So even though we may try to put safeguards into the piece of legislation, an eyewitness may actually believe and may pass the lie detector test. That eyewitness may actually have the facial recognition, and they're not lying. According to them, there's something called false memories, sometimes gaps in the memories. They may create that gaps in the memories and create a situation. So to them, it's hard for us to really see that how, even if there was a fail-safe system, Madam President, I would feel comfortable. But even with those persons given evidence anonymously, we find that you have that miscarriage of justice that could still occur because those persons have that level of thinking, of filling in the gaps. And again, there's so all of these factors have to play in the forensic individuals say there's something called visual noise, where you actually see a crime and you may think it's occurring. So there are a lot of factors that we have to take into account, Madam President. So what I'm saying now, that we know we may need to have a paradigm shift where we are depending less on the eyewitness and more on the DNA and the camera system, because I think that is the way to go. So it is frightening to me that, that the majority of the eyewitnesses in those cases would have given evidence and really believe those evidence in some of the cases due to no fault of theirs. So while I look at the legislation, Madam President, you know, that aspect of it, given those individuals, the fact that you could be anonymous, you can just, you know, you don't have any sort of way to question these individuals to see if they have some bias against you. I remember in the Scott drug report, there were allegations made after that certain characters came out of the woodwork and actually pointed fingers to some persons there, and you didn't have the evidence really to back it. So we have to be cautious that, you know, this piece of legislation is not misused. You know, and you know, could we be accused of setting up another Star Chamber? And as you know, Star Chamber, it was an English court which sat in the Royal Palace of Westminster in the late 15th to 17th century. And it was common law judges and you know, privy councillors were manning this court. Now the thing is, the Star Chamber originally was established to ensure fair enforcement of laws against socially and politically prominent people, so powerful that they thought the ordinary courts would not be able to handle them. So they thought of having these courts initially was something that was, you know, at the time it was welcome. And even Sir Edward Coke, who was an English barrister, judge, a politician who is considered to be the greatest jurist of the Elizabethan and the Jacobean eras, he quoted that this court was the most honorable court that is in the Christian world, both in respect of the judges in the court and its honorable proceedings. And it turned out actually to be a tool used to oppress opponents of the king at the time. So while I hear my own Edward Coke, our esteemed Attorney General, singing praises for this piece of legislation, we have to look at the history. We have to look with it, you know, yes, it sounds good. Yes, we want to support it. Yes, we think it's a good, you know, it may help the society at least. But then we have to look, history often repeats itself. Human nature and behavior will propel others to act in a similar way. And, you know, evolutionary psychologists think it's a matter of survival which makes people act in this way. After they may want to abuse, they may want to use the law to retain power. Machiavelli and the prince think leaders with power would use such means. So we have the history. People could take laws and actually misuse it. So we have to be careful in giving full support to this. So, Madam President, when I looked at this part of the anonymity area, I want to say that I am thinking, as Senator Vera suggested, that, you know, we have to look at the good of society. We have to look at the good because people are suffering. Now, I am looking at if we can have a system in place where the judges can look at the scientific means and personnel available to give that order, we have to put that into the legislation to utilize it. I'm also suggesting that our AG had always painted a picture that, you know, the pieces of legislation would all fit in, and I'm hoping and praying for that day because the country really needs those pieces of legislation to kick in. We really, really need that. So what I'm thinking is that if, you know, if the other pieces of legislation kick in, if the gang legislation kick in, Firearms Act, Bail Amendment Bill kick in, comes into full fruition, then if it was working good, we may have no need to come with this evidence bill because things would have been working and gangs would have been put away, guns would have been off the street, bail, people who don't deserve bail would have gotten bail. So if things were working, we may have no reason to bring this piece of legislation. But as it is there. And as the AG promised, and I'm hoping his promise of things kicking in, coming into place, I'm suggesting I can support this if, you know, to help the social ease, if we probably give it a sunset clause. probably a sunset clause for about 2 years. Give it a clause from the time, let something kick in there to see what would happen, what would transpire with all the mechanisms, which I'm hoping do kick in, do actually comes into fruition and actually will give us some sort of ease in society. So, Madam President, as I close, I would just want to mention that the other part in this legislation, which I actually applauded, was the piece in the legislation where it actually took into account that, you know, that trauma to witness, that those are the persons, the vulnerable witness. So 12 AAA, I was pleased to see that we are now looking at conditions that you know, that new subsection 3, vulnerable witness, it means a witness whose ability to give evidence or quality of evidence is likely to be affected by reason of the age or immaturity of the witness, children, which we already see existing, then the age or the immaturity, children, or the physical disability or mental disorder. And I actually support this in cases of people who have some sort of mental disorder, also in any trauma suffered by the witness, because persons who have a victim of crime, they may suffer post-traumatic stress syndrome, and even just to come and face that person could cause great distress. So those are the pieces in that legislation where I'm looking at, I'm thinking it's good. Even the witness, Part E, the witness being a virtual complainant in the proceedings for a sexual offense, we already know re-traumatization of rape victims is something that we try to see if we can help in any way. Even when a doctor examines and questions a rape victim and they go back again by another officer, it always traumatizes them. So expedition of these cases, I think, is needed. And I also look at, further down, when we looked at, we're looking at risk factors, and Party said the risk of the personal security of a particular person, including the accused person, may be endangered, the risk of the accused person escaping, the
Senator
behavior of the
Dialsing,
accused.
you have 5 more minutes.
Okay, thank you. Thank you, Madam President. And the risk of the accused person escaping, I think we need this piece of legislation. We have seen the closing off the streets of Port of Spain, disruption to the business community, traffic. All those are things that I'm thinking if we have, you know, if all these could help alleviate that, it will go a long way. Madam President, I also want to look at this aspect of it. Yeah? We have to consider that when we are looking at the witness being threatened, we also have to think, will the system, no, let's say you're a witness and somebody is going to trying to find out who is the witness. And the witness, again, is anonymous, you know, so you don't know who is the witness. But wouldn't the attorney also, the attorney I am paying, I don't want the attorneys next to me to attack me. Would the attorney I'm paying also not be tempted to tell me, because that's my attorney, and I'm asking him, who is the witness? And again, what if the attorney's family is threatened? We are back to square one. Because here I am, I hire you as my attorney, and you don't want to tell me who is that witness. Back to square one. So again, I commend the government for the utilization of the CCTV footage in Section 12A1. We know that the UK has this system where there are cameras everywhere. The Chinese government have cameras there that they can track and do facial recognition. We can either approach the Chinese government to work with us to get this. And a lot of neighborhood associations have implemented camera system. So this again, Madam President, is something I am hoping that we can work with the government with to tie in our camera system to their camera system to give evidence to help, you know, alleviate the crime we have. So, Madam President, as I'm closing, I say thank you for allowing me to partake, and I'm hoping our own Sir Edward Coke can give us some knowledge on helping the Select Committee to get a bill that I think most people will be happy at. Thank you.
Senator Mark.
Thank you very much, Madam President. Madam President, I'm very happy to join this debate and to make my input and a few suggestions as we take this bill to another level. The Evidence Amendment Bill, Madam President, on the face of it, some of our colleagues have the view could be addressed. We could probably seek to amend it, but structurally and constitutionally, I do not know if it can be fixed. Madam President, you know I am a person who quotes from the Constitution because that is my Bible, apart from my Bible. And whilst it is not in Section 4 of our Constitution, that is a right to a fair and public hearing by an independent and impartial tribunal. It is in fact stated in Section 5(1)(f), Roman 2. So we have to be extremely mindful, Madam President, that what we are seeking to deal with as the government has advanced is criminality and violence in our society and bringing about safety and security for our citizenry. But we have a written constitution and we have something called a Bill of Rights. And Madam President, the United States Constitution and the framers of that Constitution were so concerned about having an accuser confront face to face his accused that they amended their Constitution, and it is called the Sixth Amendment of the United States. In fact, I think the United States is one of the few countries, if not the only country, that has a provision in its Constitution that says that any person who is accused, Madam President, of a criminal act must, under the laws of the United States, come face to face with their accusers. That is in their Constitution. We have it in Section 5 of ours. Madam President, I also looked at what is called the European Convention on Human Rights. And there's a provision in that convention under Article 6, Madam President, on page 10. And it reads that every person who is accused, Madam President, and of a criminal offense, everyone charged with a criminal offense has the following minimum rights. And Madam President, under this article, it says the right to examine or have examined witnesses against him and or her, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. So, Madam President, that is a fundamental right. And we have to be very, very careful in seeking to dismantle fundamental rights in our society and tilt the scale towards what can be called, as some people have described this bill, Madam President, as a prosecution paradise. This bill can, in its present form, if we were to pass it, would become a prosecution paradise, according to some commentators, Madam President. Madam President, we also have to be conscious of the fact that we know in our country of Trinidad and Tobago, all is not well in many sectors. And one of the key sectors that would be responsible for taking this bill, if it becomes law, forward in getting evidence and charging persons would be the police service. And again, Madam President, the way how the bill is structured at this time, it can really lead to a recipe that can lead to the covering up of questionable police operations, Madam President. So this is a very extremely serious matter that we are dealing with here today, Madam President. Madam President, there are so many areas of the bill in the various sections and parts that really require serious and fundamental overhaul. Some of the areas must be deleted completely if it has to pass muster. Madam President, fundamentally altered, Madam President. Madam President, when I look at the legislation, I went to England because, as you know, this anonymity order concept that we are being, or that is being inserted, Madam President, in this evidence amendment bill, found its way in legislation in the United Kingdom. First, Madam President, in a bill that had a sunset clause called the Criminal Evidence Witness Anonymity Act of 2008. That was the first bill that was introduced by the British after the law lords ruled in favor of a particularly accused in what is famously called R versus Davis. And Madam President, that bill, which became an act, was eventually, as I said, it had a sunset clause. It fell through. And it was replaced in 2009 by something called the Coroners and Justice Act of 2009. And Madam President, I do not know who have crafted this legislation. But when I looked at some of the provisions in this bill that we have before us, and I looked at, and Madam President, some of the provision were taken lock, stock, and barrel, hook, line, and sinker, copy and paste from this particular law in the United Kingdom. But Madam President, what I found very strange was certain very fundamental provisions that would protect and balance the scales of justice. I noticed that these things were not incorporated. And I wondered, Madam President, was it an oversight? Or was it a deliberate attempt to ensure that this legislation is weighed in favor only of the prosecution at the expense of the defense? I wondered. So that is why I said, Madam President, very early, from a structural point of view, you have a lot of work to be done to this piece of legislation, if this legislation is to fly. Because right now, it has no wings, you know. Madam President, it has no wings. So, Madam President, whether we look at the provisions that deals with identification, whether you deal with the whole question about photographs, you realize there are many sections in Division 1 of this legislation in which, for example, Madam President, very early in the legislation, we saw something called, on page 3 of my bill, under definitions and interpretation, something called an approved form. And it says, Madam President, approved forms means a form approved by the Commissioner of Police. And when I go through the heart of this legislation, this approved form keep propping up. But I'm saying, if you want us to pass legislation of this nature, in which people's constitutional rights are going to be subverted and undermined and weakened and violated, Madam President, I don't want any Commissioner of Police, regardless of, I like Gary, that is the Commissioner of Police. He's a nice person, good person, try his best. But I don't want him in a matter like this, Madam President, involving the rights of citizens to approve any form. That form must be approved by the Parliament and it must be appended to the law. So we would be able to determine, Madam President, balance. Because you remember, Madam President, it is the executive arm of the state that will be responsible at the end of the day, along with the judiciary, for giving effect to this measure. So we are just like we are passing through, we are conductor of this exercise. But at the end of the day, after we play our music, we go on, people dance, but they don't. So we want to have a role, Madam President, in this matter. We don't want no Commissioner of Police to approve forms. Any form or forms that are to be approved, Madam President, it must be approved by the Parliament. That is what we are here for. We are not a rubber stamp, especially when you are dealing with the rights of citizens. No, Madam President. Madam President, and there are other areas, when I looked at it, I see where, Madam President, we are referring to information. We talk about forms, and that is in Division 2 of the legislation, Madam President. And when you look at the Division 2 of the legislation, Madam President, you are seeing, Madam President, where we would want to ensure that not only the approved form before, if you look at Section 3 of 12A, we do not only want, Madam President, the investigating officer to confirm first description given by the eyewitness as recorded in the approved form, but we want it as well to be recorded in the station diary. We want that to be recorded in the station diary. So there are several areas, as I went through this legislation, Madam President, and like my colleague, Dr. Senator Dial Singh, I have a copy of the PACE legislation of the United Kingdom. I studied it too. I looked at it. And whereas in our legislation, we are talking about destroying photographs, in the PACE legislation, they say, no, Madam President, you do not destroy photos. You have to retain that, because that might be critical in a matter before the court that the defense may be able to use. So that is in the PACE law of the United Kingdom. But for some strange reason, Madam President, the drafters and crafters of the legislation have left out that. They say, Madam President, when you finish with photos, you must destroy them. PACE in the United Kingdom said, no, those things must be preserved. So I'm just giving you some examples, Madam President, where there is need for us to pay attention and to ensure, Madam President, that the government does not run afoul any further in this particular matter that is before us. And Madam President, as I rifle through these pages of the document, we saw where the identification parade that is taking place in this particular section of the legislation. We are proposing, as I have here, several new clauses in order to strengthen the rights of those persons. Madam President, you remember someone who is charged with a criminal offense is innocent until he is found guilty. But this legislation, how it is worded and crafted, could be misinterpreted because a lot of the rights of the accused is not being considered in this legislation. It seems, as I said, Madam President, to be one-sided. And the essence of the legislation hinges around, as I go further, secret witnesses. Secret witnesses. Madam President, that was for another era. As my colleague talked about the Star Chamber and the period of the Inquisition. We are in a republic, democratic, sovereign state. And we are going back to the Star Chamber, and we are going back to inquisitorial arrangements, where, Madam President, as I go immediately into this area of anonymity, Madam President, you realize, Madam, that we are asking people, somebody accuses someone of a crime, and all that person has to do, according to this legislation, is to make an application, Madam President, to the court. And if that application is granted by the court, then that witness does not have to be confronted by his accuser. That is what is going on in the United Kingdom. But as I understand it, and I may be wrong, and the lawyers may be able to correct me, Madam President, if the government, Madam President, is bringing legislation to deal with anonymity, orders as it relates to witnesses, Madam President, I would have thought that the government would have wanted to deal with a serious crime, terrorism, gangland activity, as an example. Madam President, when I was reading this literature, I was not even aware, but I became aware when reading literature that murder in the United Kingdom and piracy is bailable. These are bailable offenses in the United Kingdom. In Trinidad and Tobago, they are non-bailable. What I'm saying, Madam President, do not come here, cut and paste, bring hook, line, and sinker in terms of provisions without understanding our cultural context. Murder, treason, piracy, non-bailable in Trinidad and Tobago. In that place called the UK, murder, I saw, is bailable. So there's a different culture, Madam President. We have a written constitution. They don't have a written constitution in the United Kingdom.
Senator Mark, I just want to intervene here to ask you to just be a little more specific to the bill at hand. You're making some statements comparing the United Kingdom to here, but you're not linking it to what we're treating with, which is the bill.
Yeah, Madam President, let me deal with what you consider to be, and I agree with you. I need to, what you would say, connect the dots. Okay? And Madam President, we are dealing with this particular section of the legislation that deals with what is called, that's Division 4, Special Measures, Evidence by Video Link, and Witness Anonymity Orders. And Madam President, there is a provision in the legislation which, when I compared with that of the United Kingdom legislation, the court in Trinidad and Tobago, according to the legislation, is proposing, we are proposing that the court, Madam President, let me see if I can get the specific for you so that I can link it. The court is going to consider, Madam President, whenever an application is made. The court is going to consider. And Madam President, that is 12 AG, subsection 3. Before a court grants a witness anonymity order, the court shall consider whether, and it goes on to outline, Madam President, in the Coroners and Justice Act of 2009, the word is not consider. The court must be satisfied. And Madam President, they give you all the reasons that is going to guide the court in coming to a satisfactory conclusion before it can grant, Madam President, this anonymity witness order. In this case here, as I saw it in the legislation, all we are asking, or all we are being asked to do, Madam President, is for the court to grant a witness anonymity order, and it shall do so by considering the following. No, Madam President, it has to be more than that. This is a matter in which rights of people are being threatened, Madam President. Madam President, in a matter like this, where we are talking about witness anonymity, one would have thought, as I said earlier, that the government of Trinidad and Tobago would have been paying attention to matters like terrorism, as an example, gang activity, as an example. So you categorize the areas, Madam President, that you are going to concentrate and pay attention to. But in this legislation, it is not that way, Madam President. Madam President, if you go to 12A, Division 2 of this legislation, you are seeing where there is a voluntary arrangement that is being advanced in the legislation. So in 12A1, we are proposing, Madam President, that this section is seeking to have identification procedure take place, and the record shall be taken by the investigating officer of first description of the suspect. We are saying, Madam President, this is mandatory, and we are saying that should be voluntary. And Madam President, wherever in the legislation you have approved form, we are proposing that we add, in addition, a notation in the station diary. That is another area that wherever that appears, Madam President, we are proposing that you make those amendments to the legislation. Madam President, when it comes, as I said, to this section of vulnerable witnesses, Madam President, who is going to determine who or when a witness is vulnerable? Who is going to determine, Madam President, at the material point in time, if a witness is going to experience harm, Madam President? Is it the prosecution? Is it the court, as the case may be, Madam President? And in those circumstances, any witness, Madam President, utilizing this legislation in its current form can take advantage of these provisions by feigning or pretending that harm is going to come to me, and the prosecution will buy that story, and at the end of the day, Madam President, you as an accused and your attorney who is defending you will not have the right, as I am seeing under this legislation, under the provision that I've just outlined, anonymity section, vulnerable section, Madam President, of the legislation, you are not going to have the right, Madam President, to cross-examine your witness or the witnesses involved. What the government is seeking to do, Madam President, in this legislation is to create a situation in the legislation where a witness can remain behind a screen without you witnessing or seeing that witness, and that witness will be cross-examined via a screen. And not only that, Madam President, you are not seeing the witness, but in addition to not seeing the witness, Madam President, the witness's voice will be modulated electronically, so you won't be able to hear and understand, Madam President, who is giving the evidence. Madam President, that cannot be fair in a society that has respect for democratic rights and freedoms. That cannot be right in a society that is seeking to balance the scales of justice. It cannot be fair, Madam President. And this particular section of the legislation, Madam President, along with the earlier sections I mentioned, is cause for alarm and serious concern for us in the opposition. And therefore, we are suggesting that, and we are hopeful, Madam President, that when this measure, as we were informed by the distinguished leader of government business, when it is referred to a select committee of the Senate, we will get an opportunity, the members of that committee will get an opportunity to bring very important organizations before that select committee, so we can get a better understanding and appreciation of their concern. Madam President, I didn't hear from the Attorney General whether he received any communication from the Law Association of Trinidad and Tobago. I know that when we were dealing with it, it was aborted because he was awaiting further communication from the Law Association. We would like to know, Madam President, if the Honorable Attorney General would have by now received any communication from the Law Association. Madam President, this particular provision in the legislation can be subject to abuse, Madam President, and therefore it is incumbent upon us to ensure that there are certain safeguards in the legislation to ensure that the rights of both parties. Madam President, you're talking about the accused and you're talking about those persons and so on, the defense. So those persons, the victim, the person and so on who has been subject of aggression, as well as those persons who has committed, or the person rather, who has committed the act of aggression, there must be some semblance of balance insofar as rights and privileges are concerned in a society that has respect for the rule of law, Madam President. So, Madam President, these are some of the areas that we have looked at, I have looked at, and we are putting forward for the committee's consideration, the AG's consideration. We would like to, Madam President, indicate to your good self and the Attorney General that if we are going to introduce this concept of witness anonymity orders, it must only be available in limited circumstances. And it must be in the context of fundamental guarantees of a defendant to meet and face and cross-examine his accusers. It cannot be, Madam President, it cannot be that the government is seeking to put this matter across the board. Cannot be. And at all times, Madam President, we have to balance the rights of the accused against the rights of the witness in regard to this question about anonymous testimony, Madam President. So, Madam President, these are the concerns that I would like to put on the table this evening for the consideration of the government. And we want to ensure that at all times, Madam President, trials are fair and there is balance as it relates to the rights of those persons who are involved in the exercise before the courts of Trinidad and Tobago. Madam President, in this context, the law as it stands, now is extremely dangerous and far-reaching. And we call on the government, when they are considering this matter, to have the widest possible consultation with the various interest groups so that this matter can be properly addressed and properly ventilated, Madam President. I thank you very much, Madam President.
Attorney General.
Madam President. Madam President, I'm very pleased to wrap up this debate, and I thank all senators for their contributions. Certainly this has been a fulsome debate, and if I were to underscore in the importance spectrum where this bill lies as one of the most important laws that we as a parliament and we as a country can debate. Let me repeat that. This law is one of the most important laws that we as a parliament can debate. Senator Vera had the exact submission. It is for us in this parliament to pass this law. Why? The Constitution says that we make, in Section 53, laws for the peace, order, and good governance of our society. Section 2 says that the Constitution is the supreme law. Sections 4 and 5, the fundamental rights, the Bible of rights that Senator Mark quite correctly refers to, are subject to and subordinate to the Constitution. And the Constitution itself in Section 13 and in Section 54 prescribe the manner in which we may derogate from rights in the Constitution, the manner in which we may accept that the Section 4 and Section 5 rights are not absolute. Has that been upheld at the highest level possible? Certainly in Trinidad and Tobago, that is the case. The Court of Appeal judgments in Northern Construction, in Barry Francis, you name it. In the Privy Council, the Locus Classicus, in the Surat case, and Baroness Hale in particular, in her position that not every right is, of course, an absolute right, nor does one need to call into aid the 3/5 majority out of necessary purpose, even though it may touch and concern a 3/5 right, a 4 and 5 right. So let's get to the crux of this debate. This bill proposes very important core concepts. I respectfully take no guidance from Senator Mark on the law. None at all. According to Senator Mark and the UNC bench, there are two views. Because certainly Senator Sobers, Senator Ramdeen, when he spoke, there was a young lady who spoke on the UNC bench, forgive me, I forget her name, Senator Bisram Singh. Those submissions, even that of Senator Hussain, seem to collide with the leader of the opposition bench, Senator Mark. In this particular position, the law has been cast in very simple purpose to do the following things. Number one, to introduce special procedures identified in the law. Number two, to introduce a core concept of witness protection where we introduce anonymous witness evidence by way of anonymous witness orders. Number three, to introduce the viability of CCTV evidence. If we were to desiccate the law, put it into its most nuclear form, those are the three main purposes in the law. In dealing with the proportionality of this law, obviously we must first traverse whether there is a legitimate aim. Are the measures in this legislation rationally connected to the legitimate aim? And have we gone only so far as we must in treating with the law? In other words then, is the law proportionate to the measures that are attached to the legitimate aim? Where is Trinidad and Tobago today? What is occupying our attention? I came across recently the submission in 1973 when the constitutional provisions were being looked at. And in the 1973 reflections, there was a commission established to look at what Trinidad and Tobago sounded like. And I am able to say that Trinidad and Tobago, in the reflections coming then, looked very properly like it does at present. Trinidad and Tobago had inside of its positions in that publication a description of society which fit with what it looks like today. They were reflecting upon people being fearful, people being locked into their homes, rampant criminality, guns, ammunition. And that was in the early 1970s. Fast forward to 2019, our society doesn't seem to have changed much. We heard the contributions coming a little bit earlier about connecting the dots, about Senator Diyal Singh's position of perhaps supporting this legislation if there were other laws that seemed to work. So I'm bound in speaking to this law to speak to the rational connection of this law to other pieces of law. I'm bound to speak to the constitutionality of the law. I'm bound to speak to why this law is not excessive. Question is where to begin. We know for certain that the criminal justice system is spoken of as a bare thing. The criminal justice system. The criminal justice system is not working. But what is the criminal justice system? What makes one capable of having a determination of guilt or innocence? What allows a person who is a victim to have justice considered and delivered? What allows somebody who is an accused to have justice considered and delivered? How does society foster that arrangement? What is Trinidad and Tobago today? Trinidad and Tobago today is pre-PACE reform. In the reforms in the United Kingdom, you often refer to pre-PACE and post-PACE. In the pre-PACE, PACE reforms, we're talking about the use of things like preliminary inquiries, old school evidence approach, lack of technology, and the English system saw a reformation where there was an abolition of things like preliminary inquiry, modernization of the rules of evidence, modernization of court processes. We right now foster preliminary inquiries which can run as long as 20 years. And if you are in a preliminary inquiry and you are on a charge for murder, you are incarcerated for up to 20 years in pre-trial incarceration. It costs the taxpayers of this country anywhere between $15,000 to $25,000 per month per prisoner. And we have spent billions of dollars in our society going absolutely nowhere quickly. So this system, which is the root of this bill, this system which this bill fits into, this system was a very purposeful form of reformation by this government. Put in its simplest version, we looked at the structures. To have a trial, you need a court. To have a court, you need a judge. To have a judge, you need a defendant. To have a defendant, you need a prosecutor. To have a prosecutor, you need to have rules managing the system. You need a witness. You need the articulating elements around the witness, which are the police, which are the prisons, which are the support officers. In the shortest form possible, you are aware that we went to work, increasing number of judges, increasing number of courts, increasing processes, divisioning the courts, criminal division, family and children division, civil division. The true test of that was added upon by putting a layer of rules, criminal proceedings rules, children's proceedings rules, family proceedings rules, maintenance rules, civil proceedings rules, as they were amended again. After that came the plug-in of laws, anti-gang laws, laws to treat with firearms, laws to treat with crimes involving money, laws to treat with how we manage the hard structures. Are these laws working, as Senator Dialsing asked? Yes. We have had arrests under the Anti-Gang Act. Yes. We've had people denied bail, up to yesterday, denial of bail for having been caught on the two-strike principle. Are we seeing the money laundering and other provisions at work, which is another layer? Yes, because if you can't get the hard crimes, we went behind the aids to criminal enforcement. Follow the money, follow the land, follow the companies, follow the ownership. And after we did that, we then said, how are you going to prosecute anybody if you don't have evidence? Who brings evidence? A witness. What is the risk to our society at present? Witnesses are intimidated in stepping forward. Senator Vera referred to a doubles vendor being shot. The one that echoes in my mind is the mother holding her children's hands on a corner, taking the child to school, mowed down in a spray of bullets, killed as a witness giving evidence in a trial. In my own constituency in San Fernando West, multiple witnesses have been shot dead in their beds and in their homes. And today, Senator Mark, having been part of an opposition which voted down whistleblowing protection laws, let me repeat that, which voted down and saw the failure of whistleblowing protection laws, Senator Mark comes today to say, this law is to take you back to the Star Chamber inquisitorial period. And then Senator Mark jumps to the European jurisdiction to analyze constitutionality. So let's go there immediately in treating with one of the major limbs of this law, which is the use of anonymous witness evidence. That use of evidence is to be found in the bill. That is to be found in Clause 4 of the bill, where we introduce a new Division 4, special measures, evidence by video link, and witness anonymity orders, new Clause 12AA, and we go straight through to 12AH. That's one of the main planks, one of the three limbs that I was referring to. In looking at the witness anonymity orders, I would like to say, honorable members are well aware this bill has been in circulation for a considerable amount of time. Secondly, this government submitted to all honorable senators the regulations which accompany this bill. That is a first of its kind. Most usually, you get law and the regulations come years after. In advancing this law, we did the law and the regulations. We circulated the regulations. And why did we circulate the regulations? Because we wanted to make sure that honorable members had the benefit of the material which would next be on deck. We consulted far and wide. We consulted the Trinidad and Tobago Police Service, the Judiciary, the Law Association, the Criminal Bar Association, the Director of Public Prosecutions, and we received commentary coming from members of the public in the time that we allowed this bill to sit on the order paper, even though we had started division consideration. But today, Senator Mark comes to tell us that he, as an honorable senator, as he's entitled to do, has a problem with constitutionality, and we are returning to the inquisitorial period of the Star Chamber. Let me put this on the record. Trinidad and Tobago Police Service, Judiciary, Law Association, Criminal Bar, and DPP had nothing of the same quality of contribution as Senator Mark. All of them had nothing to say along the line that Senator Mark offered. And do you know why, honorable senators? That position is so because Senator Mark, in his rhetoric, parliamentary rhetoric of saying lack of constitutionality, cut and paste, didn't do it right, Senator Mark obviously forgot to go to the rest of the world where this law was considered in a different form. And I'd like to remind Senator Mark that this law is a combination of laws coming from other jurisdictions, the combination of laws as they provide reference for the witness anonymity orders is to be found in the vulnerable witness and special measures accorded in a number of jurisdictions. They include, first of all, Trinidad and Tobago. In Trinidad and Tobago, when we look at the Sexual Offences Act, Chapter 1128, when we look at the Children's Act, Chapter 4601, when we look at the Evidence Act, Chapter 702, the one which we are amending now, all of these laws already have the same position of special measures, including the fact that child witnesses, for example, or victims of sexual offences can be remotely examined. So let's start with Trinidad and Tobago law. Senator Mark is ignorant of that. I don't pour scorn on the honourable senator. He's entitled to his point of view. I'm stating it not in a pejorative sense, but ignorance of the law. Where next did we get our positions from? We went specifically to jurisdictions including the United Kingdom, New Zealand, Australia, Canada. We went to a number of jurisdictions to ensure that we had careful precedent for this purpose. But the one that I would like to point out in treating with constitutionality is specifically coming out of the European context. Senator Mark is correct. The European Charter does have at Section 6 a process of fair trial consideration that is very similar to our Constitution. But Senator Mark did not go necessarily into the law that was set out very, very, very usefully in an important case which I would like to refer honourable senators to. It's the case of Al-Khawaja and Tahiri versus the United Kingdom. It is number 26766-05 and 22228-06, 15th of December 2011, ECHR, referred to as Al-Khawaja. There is also the case of Ellis and Sims versus the United Kingdom and Martin versus the United Kingdom, decisions number 46099/06 and 46699/06, 2012, ECHR 813, which referred to Khawaja and went into detail on that. And very importantly, not the Star Chamber that Senator Mark refers to, but the Grand Chamber had a positive, ringing endorsement and consideration of anonymous witness evidence. Let me repeat that. In considering Section 6, in considering the very section
that Senator Mark referred us to, 2 cases coming out of the Grand Chamber endorsed the use of anonymous witness evidence. And very importantly, they considered absent witnesses, they considered anonymous witness evidence in 2 forms, where there's complete anonymity or where there's partial anonymity. And the court very instructively went through the considerations and elements as to when and how a court ought to use this. And yes, quite simply put, using the Davis language, it is something to be used sparingly and in very certain circumstances. Again, Senator Vera hit the nail on the head that this ought not to be the general principle, this ought to be the exception to the rule. Very importantly, there is an active debate as to whether this law in fact is procedural, that is the use of anonymous witness orders, or deeply rooted in our Constitution. There's a live debate. Does this law really need a 3/5 majority? It is open, it can go either way. And I say so because if one were to have regard in particular to the decisions in the State and Boyce, a Trinidad and Tobago case, we look at the Privy Council decision there, 2006, UKPC 1, 11th of January 2006, and then of course that case which we're all familiar with when we looked at preliminary inquiries. You'll remember the case of Hilroy Humphreys versus the Attorney General, Antigua and Barbuda. That was number 8 of 2008, delivered on the 8th of December 2008. There is an active debate as to whether, in the context in which this law is fashioned, the context in which Division 4 of this bill is fashioned, whether this is in fact a Hilroy Humphreys type or in fact a proper 3/5 majority debate. We have come to err on the side of caution with a 3/5 majority bill because the only part of this bill which requires a consideration of whether a 3/5 majority ought to be applied is in fact the use of the anonymous witness evidence. But I wish to point members to the fact that in Division 4, in Clause 4, special measures evidenced by video link and witness anonymous orders, there are detailed counterbalances to the risk to fair trial that a judge and only a judge must consider. And I would like honorable members, through you, Madam President, to focus upon the fact that there must always be the overriding consideration of the interest of justice. There must always be permitted the right of objection, because you don't use the witness anonymity without a witness anonymous process and without a witness anonymity order. You must apply to have the benefit of the order. You make that application to a judge who must consider all of the circumstances in the round, and the judge exercising a very careful jurisdiction with legislative pointers as to what the judge must have in mind. The judge considers whether to grant that, and I wish to point members to Clause 12A(G) as in golf, to be found at pages 32 and 33 of the bill. Judge must have in mind the fair trial, the interest of justice, the conditions, the right of the accused person in criminal proceedings to know the identity of the witness, the extent to which the credibility of the witness concerned would be a relevant factor, whether the evidence given by the witness might be the sole or decisive evidence, whether evidence of the witness could be properly tested without his identity being disclosed, whether fear of giving live testimony intimidation is well grounded and that the risk justifies it, whether there's reason to believe that the witness has a tendency to be dishonest, etc., etc. This is amplified by the proposed order must be considered in the context of safety to the witness, serious damage to property, real harm to the public interest, and 12A(G) sets out, in combination with the other measures, the preservation of due process. The preservation of due process is the Surratt principle, which tells you that you have the exception to being bound by a Section 13 requirement for a 3/5 majority. So it's debatable. Do we wish to run the risk of debate in the court? Because we could consider this on a simple majority basis. But do we wish to run that risk is the question. It is by far better a proposal to invite honorable senators to put the clothing of protection that Section 13.2 of the Constitution offers. Because that Section 13.2 clothing has never been tested in our courts. The Privy Council is yet to consider the proportionality being preserved in a democracy such as Trinidad and Tobago within the meaning and context of Section 13.2 of the Constitution. So, honorable members, that's a lot of legalese. That's a lot of protection. In a short way, I can say, this law is constitutional. This law is proportionate. The rational aim is to have the statement resoundingly said by this Parliament that witnesses' lives matter too. Let me repeat that. Witnesses' lives matter too. They are being assassinated. They are being intimidated. Let me draw a litmus test for anyone who has ever gone to the Hall of Justice and witnessed what the room of jurors who are called to do service do when they turn up to say, I don't want to be a juror. The cup runneth over. Hundreds of people turn up in the High Court. Every man jack with a medical certificate or some reason why they cannot serve as a juror. I see Senator Sober smiling because he knows it's true. Why they cannot serve as a juror, you know largely why? Not me and no jury, they say. I don't want to face down no criminal, they say. If a juror could think that way, and I want to say this, the characteristic of the juror that turns up for exemption is usually your best and brightest and most affluent. True or not true, honorable senators? So you leave your category to the largest representation and litmus test. Nobody wants to be a juror. Certainly not in a capital matter.
Mark was never invited.
But, honorable members, this law provides an opportunity in very rare and careful circumstances, statutorily prescribed, using the benefit of the chamber from the European Court, telling us what the prescriptions ought to look like, telling the judge to do it, but there are further safeguards, honorable members. In our system of assize courts, you still have the right of appeal, Court of Appeal, and to the Privy Council. Is there evidence that this law has been tested all the way through? The Grand Chamber certainly tells us that, in the cases I've referred you to. The Supreme Court in the United Kingdom, House of Lords in its day, certainly tell you that. Our courts tell us that, but if you ask the average person, ladies and gentlemen, honorable senators all, through you, Madam President, let's use a live example. Trinidad and Tobago is in the habit of replicating the Roman Colosseum. Let me explain what I mean by that. The Roman Colosseum was the venue that opiated the Roman masses. How? By sacrificing Christians and gladiators to the sword and to the lions. We seem to relish as a country in gore, bacchanal, scandal, and death. Read our newspapers. They don't look like the United States newspapers. There have been close to 130 mass murders in the United States of America. And mass murders when more than 4 people are killed in one shot. Not a reflection in their papers. Jamaica, which is living under a state of emergency in certain parishes, not a reflection in their papers. Guyana, not a reflection in their papers. Trinidad and Tobago, from page 1 to the sports page, all you could see is gore and guts. Our country witnessed, in the use of video evidence, CCTV evidence, a most horrendous example. A lady had an epileptic fit on the road, fell to the ground. Cameras caught her live. A car rolled over her head. Twice. 2 vehicles passed on the CCTV camera footage and looked out the window and continued along. Our country, which prides itself on God is a Trinity and God will help people, we saw viral video evidence going around by WhatsApp telling us that nobody would stop to look at this woman. And why? Is it because we are that insensitive? No, perhaps. Is it because the people who were passing were fearful that that had happened by virtue of some crime and therefore did not want to find themselves as witnesses in the event? Doesn't this law in the use of CCTV evidence allow us for the first time in our country to use CCTV evidence? To allow a witness who may be fearful to step forward and say, I am prepared to think about being a witness if I have a chance at doing the right thing safely. Isn't that how Crime Stoppers was born? Anonymous tips, etc., honorable members? I'm not saying that the danger of the pendulum swinging too far doesn't exist. I'm pointing to the rational connection to an aim, which is something in our society that we can recognize by litmus testing. And I'm saying that the law provides prescription in relation to these matters. I'm saying that superior courts of record, all the way to the highest appellate divisions, have considered this issue, and none of them speak the way Senator Mark has spoken today. If we were to refine Senator Mark's submissions, yes, there's need for concern. And therefore, Madam President, if I may ask what time I end in full time?
2 minutes past 7.
Much obliged. And therefore, I say that yes, there's need for caution. This law is not complicated. Let's deal with the first part, the second division in clause 4, because the first division is general terms. In the first division, honorable members, there is a powerful clause, perhaps you've not spotted it. We have amended the interpretation section of the Evidence Act, specifically so that when we are getting into the trial of very complex matters, in fraud in particular, that we have the evidence available by document as now defined to include any medium of storage. In other words, then, you can admit the evidence electronically. Imagine a case as it exists in Trinidad and Tobago in multiple versions where you have millions of documents by way of evidence. What are you going to do? Mark every exhibit in the formal fashion of admission? Sign every page? 1,000,000 times? That's what we're facing in our country. Clause 4, Division 1 treats with that. Division 2 treats with the special procedures. Did we invent this? Did we copy and paste it, as Senator Mark says? No, we didn't, certainly. We took an amalgamation of approaches. We took Code D, Revised Code of Practice for the Identification of Persons by Police Officers, coming from the Home Office, which is the PACE reforms. We took the Trinidad and Tobago Police Service Standing Orders, certainly number 29, Identification of Suspects. We took Standing Order number 16, Pocket Diary. We took Trinidad and Tobago Police Service Standing Order 17, Station Diary. We took Trinidad and Tobago Gazette Extraordinary, published Friday, 16 September 1994, which treats with suspect identification. We took the Criminal Proceedings Rules 2016, issued pursuant to Act number 1202. We took next the learnings out of Blackstone Criminal Practice, Turnbull Guidelines, identification of suspect by eyewitness. We didn't invent this out of the blue. We took the Criminal Justice Advisory approach coming and hosted for us, offered to us by the kind courtesy of the combination of the Canadian government and the UK government. And do you know what? That Criminal Justice Advisor and those successor advisors have been in this country working for umpteen years. Do you know what the byproduct of that was? If we listen to Senator Mark, the Evidence Act was amended in 2012. That's the last time the Evidence Act was amended. the Evidence Act as amended in 2012, leave it to the opposition's hand, was amended at section 19, subsection 4, to say that the government expert includes a forensic DNA analyst. Full stop. 5 years, 3 months, witnesses dying, can't use CCTV evidence, can't get special procedures. Why do we want special procedures? Why do we want Code D? Why do we want the standing orders harmonized? So that there's a consistency to ensure that convictions are born on the back of a consistent legislative standard. So that there's regularity, so that trials don't become ad hoc and that you don't fall apart. All that we saw by my learned friends opposite on the opposition bench was to amend section 19, 2D, subclause 4J. Insert the following words: a forensic DNA analyst. That's the sum total of the UNC's amendments to the law of evidence. That's why I take no advice from Senator Mark. None. Absolutely none. Because it doesn't address consistency and standard of identification. It doesn't address vulnerable witness special procedure approaches. It does not address CCTV. So let's convert this into what it means for Trinidad and Tobago. Why do we want CCTV evidence? What did we as a parliament do? Motor Vehicle and Road Traffic Amendment number 1, red light camera enforcement. What is on a red light camera? A camera. What does the camera capture? Your vehicle identification, your face. The bill which was laid today in the House, spot speed, a camera, a device. The National Operations Center, prospering on a program of open source CCTV evidence. It's called Eyes Everywhere. Business places putting facial recognition cameras. The internet service providers, facial recognition cameras. They are out there right now. But how do you use the evidence? This bill is how you use the evidence. This bill, this quantum leap in evidence brought by this governor, connected to what we as a parliament did. Red light, spot speed, cameras everywhere. Wouldn't you like to have the ability, like Singapore does, to prosecute even people who commit the offense of littering by virtue of CCTV cameras? Predial larceny by CCTV cameras? Heinous crimes by CCTV cameras? Doesn't that sound like the modernization that honorable members want? Particularly when you've built a system where we are about to lose the bottleneck in the judiciary. Let me connect the dots further. We have 146,000 cases that come to the magistracy every year. 105,000 of those cases are motor vehicle and road traffic offenses. 29,000 are preliminary inquiries. Take out preliminary inquiries, take out motor vehicle and road traffic, you're taking out 132,000 cases from the court. From 146. Let me repeat that. You're taking 132,000 cases from 146,000 cases that come annually. What does that mean? You have 46 magistrates in 13 magistrates' courts and 2 out courts dealing with 146,000 cases. Imagine what Trinidad and Tobago will have purchased when you have 46 magistrates, 13 courts, 2 out courts dealing with 16,000 cases, where you have computerized evidence, where you have voice recording, where you have the benefit of criminal proceedings rules, where you have a criminal division, where you can pay electronically for your fine, for your offense, for your filing fees, where you can file your documents electronically in the court, where you have a public defender system so that if your lawyer is busy, if Senator Sobers is a practitioner at the criminal bar, and is reputed to be a good one, has 10 clients and needs to be in court for 10 people at the same day at the same time, the system of the expansion of the legal aid and advice authority is such that if your counsel of choice is not available, You will be appointed a competent counsel. Your trial will move on. Why? Because we've now added legislatively, we've moved from 36 judges to 64. We've moved from 4 masters of the court, 2 installed, to 10, with another 10 to come. This Parliament, honorable members, that we sit in right now, is to be the home of the civil courts. What does that mean? The Hall of Justice moves from 10 courts to 65. Let me repeat that. 65 courts. Before 2020 has come midway, 65 courts will have been created on top of Children's Court Faizabad, Children's Court St. Clair, with their multiple courts inside of there. You're talking 70 to 75 court facilities for criminal matters alone, honorable members. And whilst we talk about Shagwanas, let me take you on, Senator Hussain, through you, Madam President. We didn't build the Shagwanas court that cost millions of dollars in excess only to find out it didn't improve the situation. Your government did. You hear the story, twist and turn all of a sudden? It but and it but and it but. The point is, the fact is, as we move to consider the opening of the family court in San Fernando at the St. Joseph's Cluny, a building which was purchased 10 years ago and is the home for vagrants, this government will consider that. As we build the Magistrates Court in San Fernando, Rio Claro, I know Senator Choate will be warmed by that one, Princestown, Arima. We are not the ones who said, let's have an administrative complex, spend money on plans, breach the Central Tenders Board Act, and not a single courtroom built. Well, what I can tell my honorable friends through you, Madam President, is wait and see. That's all I'll have to say. The proof is in the pudding and in its eating. That is all that I will say. Honorable members, the international assessors that have viewed Trinidad and Tobago, particularly in certain fora, I can't mention it in precise form, but suffice it to say it's much like our Parliamentary Joint Select Committee. You can't speak prior to the publication of reports. I just want to tell you.
Attorney General, you have 5 more minutes.
Much obliged, ma'am. I would just like to tell honorable members, feel confident and be proud of our collective effort. We have fared very well. Today, I was visited by a telephone call from an international desk, from a specialist agency in an international country partner of Trinidad and Tobago, a very large country partner. You know what the conversation was about? Dear Attorney General, we wish to come to Trinidad and Tobago with a team delegation to replicate the successes that this country has purchased in its criminal justice system, in its court processes, in its family and children division. So I take no basket from the UNC, you know. A bunch of unperformers. That's what goes on. This country can manage its reputation and will manage its reputation. Madam President, we have accepted a number of the recommendations coming from senators. Senator Sobers has raised some very sensible positions. Senator Hussain, on the last occasion, gave us a couple. Senator Choate, I wish to thank personally for the observations and recommendations that came through. Senator Vera today, all honorable members who spoke. I think I'll only exclude Senator Mark from the equation because he was so far off into the wilderness of the lack of research. But what I can say, bearing in mind that, and in particular, due to the fact that we received further submissions from the Office of the DPP and the Law Association, we think it prudent to fine-tune this bill in a special select committee. And we, in fact, advised of that long before today's date. We shared that with all honorable members, and that was the government's intention all along. The purpose today was to bring conclusion to this legislation, refer it to a special select committee so that we can preserve the good work that we've done. It would be a tragedy to allow this law to lapse, Madam President. So in those circumstances, confident of the fact that we have some improvements to make, not significant improvements, but good improvements to make. Confident of the fact that the law is proportionate and that there is example elsewhere. Confident of the benefit to the people of Trinidad and Tobago. I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Evidence Act, Chapter 702, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Evidence Act, Chapter 702.
Leader of Government Business.
Thank you very much, Madam President. Madam President, in accordance with Standing Order 66-1, I beg to move that the Special Select Committee of the Senate be hereby established to consider and report on a bill entitled An Act to Amend the Evidence Act, Chapter 702, by September 27, 2019, and that the following 5 members be appointed to serve. Mr. Clarence Rambarat, Chairman. Mr. Nigel De Freitas, Member. Ms. Donna Cox, Member. Mr. Saddam Hussein, Member. And Mr. Anthony Vera, Member.
Honourable Senators, the question is that a Special Select Committee of the Senate be hereby established to consider and report on a bill entitled An Act to Amend the Evidence Act, Chapter 702, by September the 27, 2019, and that the following 5 persons be appointed to serve. Mr. Clarence Rambarat, Chairman. Mr. Nigel De Freitas, Member. Ms. Donna Cox, Member. Mr. Saddam Hussein, Member. Mr. Anthony Vera, Member. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Leader of Government Business.
Thank you again, Madam President. Madam President, I beg to move that the Senate do now adjourn to a date to be fixed.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Senator Sipasad.
Thank you, Madam President. I wish to raise the following matter on the adjournment. The need for the government to appoint a district registrar with suitable accommodation and adequate personnel to reinstate the registering of births and deaths in the Port of Spain and Environs District. Madam President, you are already familiar with the many complaints from diverse sources and groups about the poor customer service quality which the general public must endure from most of the offices of the public service. Today, however, I want to speak specifically to the need to appoint a district registrar with suitable accommodation and adequate personnel to reinstate the registering of births and deaths in the Port of Spain, Diego Martin, and environs. Since the 4th quarter of 2018, the district registry for the following areas are all housed together with the Arima district office: North, East, and Southeast Port of Spain, Central Port of Spain, Laventille West, St. Joseph's Road, Laventille East and Morvan, St. Anne's Ward, and Blanchisseuse, Northwestern and Southwest Port of Spain, Diego Martin 1st and 2nd District, St. James, Caranar, Chagaramas, and Maraval. The challenges the public face from these areas using one district registry are incredulous. Madam President, just imagine somebody from Port of Spain trying to get to Arima for 8:30 because that's when the office opens, joining a line extending into the road and waiting up to 3 to 4 hours for service, and that is assuming that your documents are in order. There is a waste in time and productivity to the many persons who must use this facility. The stress and frustration are incalculable. The facility is woefully inadequate to efficiently service the public applying for births and death certificates. Now, while the staff of the Arima District Office are making every effort to deal with the increased demand for services, they are overwhelmed daily. Even the security personnel are acting as customer service reps to assist the staff. However, they just do not have the necessary physical, technical, and human resources. Therefore, Madam President, there is an urgent need to have a district registrar office dedicated to serve the people in Port of Spain, Diego Martin, and the environs. The public sector must get serious about customer experiences. Government agencies need to build a holistic view of the customer experience so they can put themselves in their clients' shoes, understand their journeys as they access services, and find out what really delights or displeases their customers. The stumbling blocks include a monopolistic mindset. Customers don't have a choice in accessing services. The principle of one size fits all. Lack of the capabilities needed to assess and address gaps in customer experiences. Those with the necessary deep analytical skills as well as the human-centered design skills are in short supply. Data which is necessary to make decisions is typically incomplete or not available. Madam President, a growing body of behavioral psychology research shows that bad events have more power than good ones to shape experiences and opinions. Negative defining moments on average affect overall government customer satisfaction scores 4 times more than positive defining moments. Therefore, good experiences by the public at public sector agencies should matter to all government leaders. Madam President, through you, I'm asking the Honorable Attorney General to advise specifically when suitable accommodation and adequate personnel will be provided for the Port of Spain, Diego Martin, and Environs District Registry so that the service delivery to the general public is significantly improved, and at the same time, the general public do not have to suffer just to comply with what is supposed to be a simple and painless process to register the birth of a baby or the death of a loved one. Thank you, Madam President.
Attorney General.
I thank the honourable member for raising this motion, and I'm very pleased to provide some comfort with the response. Madam President, it's very true that post the earthquake, there was a shutdown of the registry facility at the Port of Spain General Hospital. As the country is well aware, the central block at the Port of Spain General Hospital is a very old block, and notwithstanding the fact that a seismic report was produced in or around 2011, which demonstrated that any earthquake would likely expose hundreds of people to disaster and death, unfortunately, that was not attended to. When the earthquake came upon us, the need to quicken the pace of retrofitting the central block became immediate. And we decanted the central block, and whilst we were decanting, we had to put temporary site for placement, which unfortunately resulted in the move of the district registrar for the northern region, if I could call it that, across to Arima. That was complicated as well, Madam President, by another very important factor, and that is that the Legal Affairs Division of the Attorney General and Legal Affairs was housed at the South Quay premises. At that location, Madam President, suffice it to say, time was spent more so on putting sandbags to avoid flood, rodent eradication, document facility management. It was a disastrous place, and worse yet, none of the servers or computer software was allowed to continue in license. Regrettably, the last government allowed all the licenses to lapse, and they were still working on Windows XP. 12 computers daisy-chained together like big old Curtis Matheson boxes of televisions, the big box television. That is what was the server for the information. What we did, Madam President, is that we moved the district registrar's office to Arima. We decanted the site, and I'm very pleased to say that at the same time we moved, as the honourable member would be well aware, working in a very prestigious law firm herself, we moved the civil registry, 11 million records, 150,000 company records, and 3 million civil records. 8,000 boxes, 1 month flat. Brand new accommodation, hundreds of people. So there are two ends of the equation. the Registrar General's cycle end, that is the house and where they are and how they process, the experiences that people need to have in accessing births and deaths registration, that is back-ended or rooted in the Registrar General's facilities. We cured that. We did an epic move. And in doing that, in fact, a member of the law firm that the honorable members are part of sat on the committee that we consulted with. We demonstrated on umpteen occasions what we had done, where we were, and how we kept our word, because the entire registration system was at risk. On the hard-end receiving side, which is birth and death in itself, at the Port of Spain General Hospital, we're very pleased to say that we have in fact secured a location which is to be confirmed by the registrar, now the district registrar. That meeting is, in fact, we had several meetings already. There's one further meeting to be had, and then we'll be reintroducing that office into the Port of Spain General Hospital now that we've decanted the construction site out of the area. So we've got the space ready. But there's better news, Honorable Senator. Thankfully, we have purchased the benefit of electronic documentation. We are already in the position where we have nominated, by virtue of the Exchequer and Audit Act and by the Electronic Transactions Rules 2015, we've already nominated FCB as the intermediary to do the electronic transactions, so that people will very shortly, after registration, after the event which the hospital is going to manage at the moment of birth or the moment of death, you're going to be able to apply for these services, pay online, God willing, in the month of October 2019. You'll be able to pay online and receive everything by TT Post. By doing that, we will eliminate 15,000 people every 3 days from attending the Port of Spain office alone. Let me repeat that. Every 3 days, 15,000 people approach the Registrar General's office in Port of Spain alone. The news gets better. San Fernando is in woefully inappropriate accommodation. The Registrar General's office, which is the other back end to the San Fernando registration, even though we've got it at the San Fernando General Hospital, that office is soon to move into modern accommodation. All of this was purchased by the effort of this Parliament. Because as you will recall, we did the payment and filing laws in part in this session. What we did is to deal with the back-end software, arrange the IT structures, bring to life the electronic transactions to allow for payment, because this is now exponentially important. It means you no longer have to line up at the company's registry, which is another service, pay your $25 to register. It means that you no longer have to order your certified copies in person and pay for it. All of those services now go into the e-transaction services. It gets better yet. We have already done the specifications to do queuing on your telephone. You get to the Registrar General's office, you will receive, it's your turn while you are seated in your seat, because you now have queue management systems. So we have been spending a lot of time in what I consider to be the golden registry of Trinidad and Tobago, in making its presence much better and the experience much better. I'll end on a small anecdotal note. The first day that we opened the registry, within the 1 month time, at Richmond Street, I called the Registrar General downstairs. It was raining cats and dogs, buckets of water. And I said, RG, how do you feel? What do you notice that's different? She looked at me. After a little while of chat, she said, what do you mean? I said, it's the first time we're watching the water flow away from the building and not into the building. Those things might sound small, but I can tell you when Tropical Storm Brett was passing, it was the Deputy Registrar and the TTDF and members of the AG staff that were packing sandbags by the door to make sure that the books of Trinidad and Tobago, the golden resource, was served. I wish to pay homage and tribute to the excellent effort and work and dedication of Ms. Karen Bridgewater, the Registrar General, Ms. Nicole Moonan, the Deputy Registrar General, Ms. Rion Boyk, Mr. Francis Sandy, and the many people that work at the RG's division, including our IT staff and the support services that have managed to make this dream that we've been talking about of ease of doing business become a reality. God willing, all things being equal, the month of October is electronic transactions time. The honourable member will know that we have gone a step further in the Property Business Real Estate Solution, PBRS system, where we have digitized the system for electronic filing of all land registration, tied into GIS survey mapping information. That goes into its first stage in October 2019 and will be completed in February 2020. These are good days for Trinidad and Tobago. You have a government that paid attention to processes, to flows, to work environment. Come and see it for yourself down at the registry. We apologize to people for the inconvenience, but at least we never shut down. We had an earthquake, we had an inadequacy of position, we went to REMA. And we have done the IT and support and increase in resource personnel at the RG's division, and I am very pleased that I will be one of 2 ministers in the AG's office who will birth this for reality in the first space ever in Trinidad and Tobago. I thank you, Madam President.
Senator Mark.
Yeah. Thank you very much, Madam President. Madam President, the disinfectant for secrecy is the sunshine of transparency and accountability. Madam President, this motion calls on this government to immediately table the recently signed 126 million Australian dollars contract, equivalent to 600 million TT, between Austal and the government of Trinidad and Tobago. Madam President, we had to go to the Austal website to learn of the secret contract between the government of Trinidad and Tobago and Austal, amounting to $126 million, Madam President. Madam President, for 2 Cape-class patrol boats. Madam President, what is very significant about this is that there has been different prices given for these boats. I looked at the Newsday of August 2nd, 2018, and it is stated that an official stated that the boats were costing or would cost us $35 million US per piece or per vessel, 70 million, Madam President. Then in January, Madam President, of 2019, 6 and 7, mind your business presentation, the Prime Minister provided to this country another number, which was $600 million. So the goalpost shifted again. Madam President, we got from Austal in Australia a price of $100 million, and this was supposed to include a multi-year ongoing maintenance and support package. That would be $600 million. Madam President, we go further. We got from the government, from Austal, a final price, as I said, on the 16th, Madam President, the 16th, Madam President, of August, $126 million Australian dollars. Madam President, we don't know who to believe. Believe the Prime Minister? Believe, for instance, what we read about 35 million US? Believe what we got from Austal, 100 million in 2018? Believe what is in the final contract, of course, for 126 million. But Madam President, what is astonishing and requires a police investigation and inquiry is the fact, Madam President, on the 14th of December 2015, the Australian National Bank bought 2 vessels on behalf of the Royal Australian Navy from the same hostel, Madam President, for 63 million Australian dollars. Madam President, may I repeat? 2 58 meters Cape class vessels were bought by the National Australian Bank on behalf of the Australian Navy for, Madam President, 63 million Australian dollars. We are being told that Trinidad and Tobago is paying, Madam President, twice the price for the same 2 vessels. So the price that we are being called upon to pay is 126 million Australian dollars. Madam President, that is $300 million more of Trinidad and Tobago dollars. Madam President, this is not, it is surreal. You can't believe. I can't believe what I'm reading here, Madam President. I believe that this thing requires some answers from the government. Why are we being called upon, Madam President, to pay $300 million more for 2 vessels that cost the Australian government $300 million for the 2 vessels? So something is amiss. Something is wrong, Madam President. And I have brought this matter to your attention today so we can get some answers from the government. The first thing we want them to do is to table the contract in the Parliament for us to see, Madam President, and for the public to see. We also want, Madam President, for this government to tell us what is going on with this contract. Madam President, it is either we are being taken for a ride by this builder or hostile in that country called Australia, that is Trinidad and Tobago, is being taken for a ride, or the government of Trinidad and Tobago is taking the citizens for a ride. And we need answers, Madam President, on this matter. This is why we would like the Honorable Minister of National Security to tell us what has gone wrong. Why are we paying that kind of price? And Madam President, may I remind you, when the Prime Minister and his Minister of National Security visited Australia in the month of May 2018, after going to Beijing in China, between the 14th and the 19th of May 2018, when they arrived in Australia, the first port of entry, the first port of call was hostile. They went to hostile. And Madam President, we want to know what is going on here. We are not accusing anyone of anything at this time, because we are doing our investigation. We are going to write to the police commissioner on this matter, because, Madam President, Trinidad and Tobago, in the kind of crisis that we are in today, cannot afford to be taken for a ride by anybody for $300 million more, Madam President. Madam President, how can that be real? We need answers, and I hope that the government can provide the citizens of this country today with answers on this matter. Madam President, I have the evidence before me. I have all the evidence. We have done the research. It is a 58 meters in length vessel, Madam President, that can take you 4 1,000 nautical mile range. That's the range. It can remain out there for 28 days patrol cycle with a crew up to 22 members. Madam President, we are told that this vessel that we are buying from these people suffer from severe defects. The Border Patrol of Australia or the Border Force of Australia, they are experiencing a lot of difficulty with this particular vessel. So we would like to know what are the guarantees that are being given to us. Madam President, we understand from our research that there are 8 similar vessels being used by the Australian Border Force, formerly the Customs and Immigration Department, and which are experiencing frequent breakdowns because of what they call stern tube deficiencies. Madam President, we have been able to access 2 reports, one in December of 2014 and one in December of 2018 by the Australian National Audit Office, which identified and highlighted severe deficiencies in these vessels. So we want to know if the government would have done, Madam President, due diligence on this matter before they did it, before they purchased this vessel. Madam President, in closing, we want answers. We want answers. Explain to this Parliament why it is costing more, twice the amount of money for the same amount of boat. Thank you very much, Madam President.
Acting Minister of National Security.
Thank you very much. Madam President, at the outset, let me state quite clearly there is no legal or constitutional or parliamentary requirement for any contract signed by government ministries for the provision of goods and services to be made available to be tabled in the Parliament. There is none. We're starting with that. Accordingly, no undertaking has ever been given by this government to table that or any other signed contracts. This government has been optimally transparent in its conduct of public business, Madam President, and has consistently informed the public of its actions and decisions in relation to this matter. The affairs concerning this purchase has been extensively reported in the media, buttressed by numerous statements by the Honorable Prime Minister and, of course, the Minister of National Security. During the CARICOM leaders' meeting in July 2017, the then Australian Minister of Foreign Affairs invited the Prime Minister to visit Australia. Following this, during the Commonwealth Heads of Government Conference in London in April 2018, the Prime Minister requested a bilateral meeting with the then Australian Prime Minister. In that productive and worthwhile meeting, it was agreed that Trinidad and Tobago would procure 2 naval vessels to assist the Trinidad and Tobago Coast Guard in shoring up our borders and securing our citizenry and our property and assets in that way. Like the ill-fated OPVs, these were engaged on the advice of and at the request of the Trinidad and Tobago Defense Force. This didn't come from whim or out of our head. In May 2018, Cabinet agreed that the Prime Minister would lead a delegation to the Republic of China and as well to Australia. During the delegation's working visit to Australia, the Australian government arranged meetings with shipyards, both INCAT and Austal. Subsequent to these visits, the Office of the Prime Minister issued a press release under the headline, "Government Actively Looking for the Best Marine Vessels to Service Trinidad and Tobago." This was done in the essence of openness and transparency. We chose 2 shipyards, Madam President, so that the construction of these vessels could happen simultaneously rather than in a line, one after the other, because we needed them to tighten up our borders with urgency. Upon return of the delegation, a press conference was held where the public was informed of the details of the visit to China and Australia, including the fact that the government was interested in procuring Cape-class patrol vessels to strengthen our border security. and to reduce our vulnerability that they complain about every minute, every day. Madam President, this too was done in the essence of and the honor of transparency and openness. During the period June 24, 2018 to July 1st, 2018, a delegation from Trinidad and Tobago Defense Force visited Australia, and they conducted an assessment of the hostile Cape-class patrol vessels to finally decide on their suitability for use by the Trinidad and Tobago Coast Guard. The Trinidad and Tobago Defense Force delegation submitted a report which came to the government dated July the 3rd, 2018, in which the recommendation was made by them to acquire the 2 Cape-class patrol vessels. This was not only prudent, Madam President, but it also was the essence of openness and transparency and the way to do government business. I heard the senator talking about secret, but he said he saw it on a website. A website can't be secret, wherever you see it. And he talks about the cost discrepancy. But he buttressed that by saying he saw a statement supposedly from some official in the Newsday. That's the evidence he wants to use to talk about the price. The Australian government, he said, pay one price for their vessel and we paying more. That is like buying an electronic massage chair for T&Tech, taking it home and using it like a Morris chair. That's equivalent to that. He cannot tell you one word about specifications, one word about capacity, but he is shouting loudly about the cost, and he knows nothing about it. The only thing that cost this country more than $300 million was the QREP interchange, where they were costing us $620 million. We are doing it now for less than $300 million. That's the only thing. Following all of that, the cabinet appointed an evaluation committee, a sub-cabinet team, and it was set up to review the proposals received from Hostal. Based on that committee's recommendations in July 2018, the cabinet agreed to acquire these 2 patrol vessels for the Trinidad and Tobago Coast Guard to patrol offshore. One of them, or even the OPVs we lost, could have been down in the Bahamas right now, spend 6 months servicing the people of the Bahamas. But they had the temerity to tell us we should send vessels down there. Madam Speaker, the other cabinet also agreed that the government would pursue financing the arrangements with the Export Finance of Australia. That's the government's export credit agency, as well as financing from the government of Australia to fund these vessels. Thereafter, and only thereafter, the Ministry of National Security proceeded to order the 2 Cape-class patrol vessels. The contract for the purchase of these vessels was signed on August the 15th, 2019, and some monies was paid in advance in accordance with the contractual terms. The vessels are expected to be delivered in the second half of 2020, a wise decision to do them simultaneously rather than one behind the next. You understand, Madam President? We have absolutely no secrets. This government is the epitome of openness and transparency. The most open government for years in this country. It is this one. But what they want, Madam President, is to scandalize and to sandalize this arrangement, but they can't touch it. They can't touch it. That's what they want to do. That's what they want to do. Madam President, they wrote, he's threatening now to write the police, but they wrote the Attorney General of Australia in this matter, who dismissed them out of hand.
Them Australian stoops.
Stoops at them in Australian accent, dismiss them, and I'm sure the same would happen when they write the police commissioner here. The government has been more than proactive in disclosing details surrounding these purchases, and the records would show that there were a host of media engagements dealing with this issue. And in fact, I can boastfully say that the approach we have taken in the purchase of these vessels is a blueprint for future transactions. We didn't just go down China and say, in a drunken state, give me one of that. You see the process we went through.
46-1, if the minister wants to speak about his drunkenness, that is his business.
Not mine. I'm a sober man. I'm a sober man. Madam President, that is the way we did it. And Madam President, as I said, we didn't do it wildly and whimsically. I've outlined the careful processes that we have gone through, and that is all done in the interest of the people of Trinidad and Tobago. And we look forward to 2020, when these brand new Cape class vessels will arrive on the shores in Trinidad and Tobago, and we'll be able to accord the protection to the citizens and the assets of Trinidad and Tobago, including our marine and oil assets, for the benefit of all of us. Madam President, I thank you.
Honourable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favour say aye. Aye. Those against say no. The ayes have it. The Senate now stands adjourned to a date to be fixed.